Just give us a second. Sorry, we're just having a little bit of tech issue. Okay, great. We are live now. Okay, so I'm gonna share my screen. Can everyone see my screen?
Yeah.
Okay, great. So hi everyone, my name is Nipa. I'm a hotline specialist with Housing Court Answers, and then my coworkers are gonna also introduce themselves.
Hi, I'm Angie. I'm also a hotline specialist, and my pronouns are she, her.
Hi, everyone. I'm Sarah. I'm also a hotline specialist, and my pronouns are also she, her.
And then we have also, sorry, my pronouns are she, her, and we have a special guest today, Kenny Schaeffer from Legal Aid Society. He is a lawyer and he will be assisting us along with answering some of your questions today. So we will take questions. We just will take them at the end. So if you have questions that come up throughout the training, just make sure to put it in the chat box and then we will answer them at the end when we have time. Yes, if you want to say anything, Kenny.
Just hello. You'll be hearing a lot from me, I guess, during the afternoon. I am Kenny Schaeffer, a longtime friend of Housing Court Answers. I'm a legal aid housing lawyer in Queens. Started in the Harlem office and then moved to Queens.
Okay, great. So we're gonna get started. And yeah, great. And we will be sharing this presentation with everyone afterwards. So don't worry about, having to take pictures or anything. We will share them on our website and the recording will also be available. Okay, great. So what is Housing Court Answers? So Housing Court Answers is a nonprofit organization, and we assist people who are unrepresented tenants and homeowners. So people who don't have lawyers like Kenny.
Excuse me, Nipa, sorry. Some people are saying they can't see your screen share. Sorry.
Oh, sorry. So can you see it now?
I can see it. I'm not sure if people want to put in the chat.
Yeah. Okay, great. Perfect. People can see it now. Okay. Okay, so what is Housing Court Answers? So Housing Court Answers is a nonprofit that provides assistance to unrepresented tenants and homeowners. So unrepresented means they don't have great lawyers like Kenny to help them through the case. How we work is we help unrepresented tenants and homeowners understand the housing court procedures. We help connect them to free lawyers now in very limited circumstances. As I think most of us are aware, there's a capacity issue with the free legal services. And we also have information tables in the Bronx, Brooklyn, Manhattan, Queens Housing Court. So we're not there every day, but we are there to help you fill out basic forms. We also have a hotline and we will share that number with you that you can call. Disclaimer. So we are not attorneys. None of the staff members and that you speak to on the hotline or in the courthouse are attorneys, so we cannot give legal advice. And this training is just a general overview of orders to show causes and what they are and how they should work. It should not be considered legal advice, because as we're not attorneys, we cannot provide legal advice. And this training only applies to housing court in New York City. Other types of courts, sorry, Other types of courts and other counties have their, remember, we live in New York City, we have our own mayor, things like that. We have different policies and procedures than most of the state, so we cannot speak to the OSC process in other types of court. But these are some general best practices to follow when filing for an order to show cause. And every case is specific, so please just reach out for guidance if you are confused. You can feel free to use this training as a guideline, but again, every case is specific. Sorry, just give me 1 second. Sorry, I'm a little sick, so bear with me. So today what we will be doing is we will be showing examples of order to show causes that pro se tenants have filled out, and also just some general guidelines. It's not going to include every single type of order show cause that's available. It'll include the most common ones and used in non-payment and holdover cases. So pro se means tenants who don't have representations, because these are the type of tenants we work with. So just explain how to fill out those forms. What are things, considerations of information you should put down when filling out the form. So what is an order to show cause? An order to show cause is a court order, a document submitted to the court, which, if signed by a judge, orders that something be done or not be done, and sets a court date in the future where both parties will be heard. Again, the type of order to show cause we're talking about is specific to the housing court procedure. I forgot to mention that. This is not even talking about an order to show cause in other types of court. This is specifically to housing court itself. So just be aware about that. Housing court within the 5 boroughs of New York City. We don't have tables in Staten Island, but this is relevant to the Staten Island courthouse also. What are the types of order to show cause? There are 4 main general types of order show cause that we will discuss today. It's vacating a default when a tenant misses a court date or never has filed an answer. Getting more time to pay in a non-payment case, getting more time to stay in a holdover case, and restoring a case to the calendar if repairs aren't made. So there's 2 types of cases that landlords can file in a court, which is non-payment, which is a case about back rent. So if you pay, you generally stay, and holdover, even if rent is being paid, they want you out. There's HP action, which is repairs case. That's the type of case a tenant can file. There's also harassment, but we're not going to talk about that. But these are generally the 4 types of order show causes.
I just want to add, for people to understand procedurally. So an order show cause is when one party goes to the court without the other party there and asks for something. In this case, often there's a marshal's notice, and you're asking the court to stop the eviction temporarily and to give a court date in the future after the papers are served on the other side, so the judge can hear from both sides. So that's something that you file, and the judge doesn't see. They'll look at the whole court file, but they won't hear from the other side, and they'll decide whether or not to sign the order to show cause, give you any immediate relief you're asking for, which we'll get into a little later, and then if they sign it, give you a court date in the future.
All right, thank you for that. I think most people will deal with an order to show cause usually when they get the marshal's notice or notice of eviction. So the order to show cause, for now, it's temporary. When you initially go in, it's a temporary order until there's a new court date and the final decision will be made.
And let me just add on that. Very often, depending on the situation, if the circumstances warrant, you want to file an order to show cause before the marshal's notice is served for a number of reasons, which we'll get into a little later as well.
Definitely. Okay. So, and
okay, I think this is me. How is an order to show cause filed? Sounds scary, but you can do it. You have to physically go to the court. Oftentimes we get folks who ask if they can do it over the phone. You can't. If you do have an attorney who can do it, sometimes they can do it through NICEF, through the e-filing court system, but it's much easier to just do it in person. So you would go to court, you would get on the line at the clerk's window, and they would give you hopefully the appropriate form. Usually they help you figure out which one you need because, like we said, there are many different types of orders to show cause depending on your situation. So you want to make sure that you're very clear with what's going on. If you have a marshal's notice, let them know. If you haven't been to court in a while and you're trying to bring the case back to the calendar, let them know. And again, you can ask for guidance. You can ask the clerks. There's also usually an attorney on staff at the court. You can ask for the room number to speak to them. And we're usually at the tables as well in all the boroughs except Staten Island.
And one thing I want to add to that. So when you write an order to show cause, it's a document that you're showing to the judge. You're not writing on a blank piece of paper. The clerk will give you a form, again, supposedly that's relevant to your situation, and you'll fill in the blanks, check the boxes, and there'll be a space to add additional information, which is very important, and we'll get to that later as well.
Okay, so the first general category of order to show cause that we're going to talk about is in order to vacate a default. A default is where a tenant has failed to participate in their case in some way, right? So maybe the case has been started in court and the tenant never came to a court date, or they never came to file an answer to a non-payment case. And the court has no idea why the tenant wasn't there or didn't participate in the way that they were technically supposed to. So when the tenant either has failed to show up for a court date so they know about it, or when they receive papers telling them that a judgment has been issued against them, they come to court in order to ask for their case to be reopened in a way. So a default judgment is where the court finds against you for just failing to do something. And the warrant is what allows a marshal to come serve you with a marshal's notice. So when you're asking the court to go backwards, you have to give them reasons to do this, right? And usually what a judge wants to see is both an excusable default, meaning the reason why you didn't do the thing the court expected from you, and also a meritorious defense, meaning that you have some kind of defense in this case to begin with, right? So an excusable default, maybe you never received the court papers that started your case. Maybe there were problems with the mail delivery. And if that's the situation, you want to explain how you found out about the case. Often it's because a marshal's notice arrives, so you rush to court to do the order to show cause. But maybe you got a letter from HRA telling you about the judgment against you. Maybe the super mentioned something. So explain how you found out about the case. If you missed a court date, explain why you missed it. Was there a medical emergency? Did you get confused about the court date? You thought it was one day, but it was actually another. Maybe a childcare issue. Maybe your job wouldn't let you off of work. Whatever reason you give, it's stronger if you can attach proof of what was going on. And this helps the judge to understand what you're saying and also to believe you when you say whatever you say. So the document that you get usually will have a space for, oh, sorry, next slide.
But before, back on this one.
Sorry.
Just real quick, so people understand, what we're talking about when we say vacated default is either missing a court date or never having answered. So we mentioned earlier that there's two kinds of cases landlords could bring: a non-payment case where they say pay the rent or leave, and if you pay, you get to stay, or a holdover where they say your time is up, you have to leave. It's not just about the rent. So with a non-payment case, there's no court date set initially. The tenant has to answer, and then they'll get a first court date. So a default in a non-payment could either be they never put in an answer, or they put in an answer, they got a court date, and then they didn't show up in court on a court date. In a holdover proceeding, the papers come with a court date. So a default in a holdover would mean you didn't show up on the court date that was set. Just so you're clear about what we're talking about here. And meritorious defense, we're trying to avoid big long words and legal terms. It just means a defense. The judge, if you don't show up, you lose because you're not there. The judges like to open up a case and decide the case on the merits, but they don't want it to be a waste of time. So they want to know, like, is there a good reason you weren't there? And we've gone with that. And do you have a defense to the case? If it's a non-payment case, do you have a defense or a holdover, whatever it is? Would it be a waste of time for the court to open it up because the tenant has nothing to say anyway? So you always need to put in some kind of a defense, and we'll get to the specific kinds of defenses in the upcoming slides.
Thank you. Great, thanks. So defenses, so meritorious, valid, it's what the judge is looking for. Does it fit the type of case? So non-payment defenses and holdover defenses could be different, right? With non-payment cases, the most common defenses are that the landlord violated the warranty of habitability, meaning they failed to make repairs that they're legally required to. You may want to list repairs, have photos, take photos and have them ready for when the time comes. Maybe the landlord is claiming an amount of rent that you think is wrong. Maybe they calculated it wrong. They didn't give you credit for some payments that you made. Maybe there's an overcharge issue at work here. Maybe the landlord refused to take the money for some reason. And also maybe the papers were not served properly. Holdovers, there's so many different reasons why a holdover might happen, so we don't want to be too prescriptive, but defenses could be that if the case was started as retaliation for you complaining to a government agency about repairs or about harassment, maybe you actually have succession rights to this apartment. You're a family member of a rent-stabilized tenant of record. Maybe this is your mother's rent-stabilized apartment. She passed away. You've lived with her for 2 years, so you should have succession rights. But the landlord is treating you as if you're not someone with those rights. And again, maybe the papers weren't served properly or with enough lead time. Maybe it wasn't the right type of papers. And these might not be defenses, but maybe you just need more time to move, more time than the landlord was willing to give you initially. And you're hoping that this case can give you more time. Kenny, did you want to add to this?
No, not necessarily.
Okay. Next slide. All right.
I'm sorry, I did want to say one thing. I apologize. So you don't have to go into great length, but you have to hit the magic words at least to put forward a defense. You don't have to go into the whole history. The landlord's retaliating because I made complaints about mold in the bathroom. Just in a few words, but make sure you put enough there to let the judge see that that you have a side, or the person you're helping fill it out, that they have a side of the case. It's not all what the landlord says.
Okay. So sympathetic factors. So orders to show cause, a judge is allowed to use discretion in making their decision, meaning they can't always say no, but they can also say yes to things that aren't necessarily, what the law prescribes exactly. So you can bring up sympathetic factors, like the length of time that you have lived in this apartment. You can bring up if it's rent stabilized or rent controlled. Do children live in the home, or seniors, very elderly seniors? Do the tenants have health issues that make it extremely hard to leave, or that have made it difficult to apply for assistance with back rent? Have there been changes in the household income? So all of these sympathetic factors can help get the judge to be more generous or lenient with you. But also don't forget to include your plan to resolve the case, right? It's not enough to just write on the paper, I have cancer, but also explain more as much as you can, right?
Yeah, just to add to that. So what we mean by discretionary is that the judges in housing court can rule pretty much any way they want on any case, on any issue. They can come up with a theory to support one side or the other once they've decided who they want to rule for. So part of the job is to get them sympathetic to your side. And that's why you want to put these sympathetic factors. It's not just a factor that the person's lease expired, they didn't leave, boom, they should leave. But hey, they've been there 28 years, or someone's has a home health care aid, or whatever the situation. You want to humanize it for the judge, so it's not just a simple procedural issue, but it's a human issue. And again, whatever the defenses are, the judges want the cases to end sooner than later, so they want to know there's a plan. If it's a holdover and you need more time, explain that you're looking or what you're doing. If it's a non-payment, you have an appointment at home base or whatever it may be. Just went back to work. The judge wants to see that the tenant's not just stalling, but is willing to come to a fair resolution of the case, doing the best they can, at least.
Thank you. So there is a strong public policy to vacate defaults. The idea is that it is better if a judge is going to evict someone, the ideal would be for them to evict somebody based on the merits of the case, the facts of the case. It's not great for society if people get evicted just because they missed a court date, they're in the hospital. So the tendency is to vacate defaults because, yeah, the ideal is for the tenant to actually have their day in court to go over.
Yeah, let me just add, as a matter of reality, it's easy to get the order to show cause, but if the tenant, especially without a lawyer, if the order show cause is signed and you come back to court on the return date, the judge is not necessarily just going to say, okay, I'm going to open up the default. They're going to really try to force the tenant to make an agreement and say, look, there's a judgment against you. I haven't decided whether to vacate it or not. Why don't you just agree to update the petition to include the current rent and agree to pay it in 30 days? Or it's not likely that an unrepresented tenant on the return date necessarily is going to get the default vacated, but they will at least get the order of show cause signed to stop any pending eviction and get a new day in court where you can at least make an agreement. And we'll get to what to do on the return date in a later slide.
Yeah. So now we're going to look at some real examples of orders to show cause for this type. So the first one that we're going to be looking at is actually one that got denied by a judge. The judge did not want to sign this, and we'll try to figure out why. So we can see from this order to show cause, there's a line through the first page where if it had been signed, it would have set up a court date for the future. And we can see the judge wrote, denied, reapply with proof of one-shot deal application, right? Some other useful information, if we look at the top, we see this is not the first order to show cause that the tenant has done, right? They have been in court before, so this isn't the very, very beginning of the case. And then if we go over to the paper that the tenant filled out, so one thing that is missing here for area 2, they didn't explain what happened in the case. Was there a stipulation? Was there a trial? They don't really explain what happened there. We can tell from area 3 that they were in the hospital on the court date. And then I guess they received another notice, but it would have been good if they had framed that as an excuse for missing the court date.
Yes.
Sorry, did my internet cut out for a second?
Sorry?
Oh, never mind.
No, yeah, you're fine.
Okay, sorry, thank you. Now, the tenant did mention on this order to show cause, they mentioned that repairs were not done on December 11th and 12th, and they said HRA case is pending, but they didn't attach proof. They didn't write a case number. So they're not really showing in a way that has convinced this judge that the solution is coming, right? They're not showing that the one-shot deal to pay the arrears is in the works. So that plan for how to resolve the case is kind of lacking here. I don't know if Kenny, you want to?
Yeah, a couple of
add in?
things. Yeah, a couple of things. So, and there was a question in chat about how many orders to show cause. So let's go back to the first page at the very top where it says order to show cause to restore it to the calendar. That just means you want to get a new court date. And above that, it says respondent RSP, meaning that's respondent or the tenant, OSC applications 3, which means this is the third order to show cause. So there's no limit on the amount of orders to show cause you're allowed to file, but the more there have been, the harder it is to get it signed. That's the first thing to say. And it's less like, yes, it's much easier to get a first order to show cause signed than a second or a third. Nextly, looking at the defense, the judge denied it, reapply with proof of pending one-shot deal application. We don't know if this eviction was scheduled for the next day. If it was, I would say it was an abuse of the discretion. The tenant has sworn under oath that HRA case is pending. So even though they didn't attach it, if the judge gets these papers and there's an eviction the next day, instead of denying the order to show cause, they could and should say, bring proof on the return date. Here's your court, you have a court date in 2 weeks, come back and bring proof of it, rather than just denying it, which is another reason not to file orders to show cause the day before an eviction. And we'll get into the timing a little bit later again. But the fact that the tenant said they were in the hospital on the return date, the repairs weren't made, and the HRA case is pending, that should be enough to get an order to show cause signed most of the time. But again, it's discretionary, meaning the judge could do whatever they feel like that day. So the more proof you attach, the more likely it is it'll get signed.
Okay. Can we move to the next slide, please? Thanks. All right. So this is another order to show cause, and this one actually did get signed. You can see from the judge's signature, and you can also see that there is a court date that the tenant is expected to come to that has the date, the time of day, the courtroom. You'll also see on this first page that there are service instructions. And it's very important for the tenant, after they get the judge's signature, you want to serve the document to the right people, the landlord's lawyer and the marshal, in exactly the way the judge wants it to be served. So paying close attention to that is very important. So let's look at what the tenant wrote to convince the judge to sign it. So we can see that this is a failure to answer. So basically, a case was started in court and the tenant never showed up to answer the papers, which means it was a non-payment case. And we can see from area 2, the tenant explained, I didn't know about this case until I received a marshal's notice, right? They're explaining why they never put in the answer. So that's the default. And they also mentioned in area 3, I was improperly served. The idea that they didn't receive the court papers at the very beginning when the case was started means that most likely they were not served properly. And they also mentioned they checked the box, or they checked the line, the rent has been partially or fully paid. And that's an important thing to bring up. But they also gave an explanation of that in the area right below. They mentioned that they made a payment of $1,129.81. They say when they made that payment. They also mentioned that they applied for a one-shot deal and that they completed it. They put the case number for that one-shot deal application. All of this to show the judge, I have a plan to resolve this case, and I'm showing you the steps I've taken to make that plan happen. And I believe on the next.
Before we go to the next, is that what's
Yeah.
attached? Okay.
Yeah, I was
that's
going to
okay.
say, also in area 5, you can see this is the first order to show cause they've done, which makes sense because they didn't know about the case before. But yeah, it's important to note that. But yeah, on the next slide, we're going to see some of the proof that the tenant brought in order to back up what they said, right? Because you can say you made payments, you can say you've applied for a one-shot deal. How does the judge know that it's real? This proof helps. You can see copies of money orders. Money orders are great because they come with a receipt. They've attached a letter from HRA showing that a one-shot deal has been applied for. Yeah, it doesn't necessarily say if it's going to succeed. It doesn't say how far along they are in the process. I mean, I guess it just says that the application exists. But this is good. This is the tenant bringing and attaching proof. I'm sorry, Kenny, did you want to jump in?
Yeah, just going back on the page before. The tenant did not check off that conditions are needed on number 3, the bottom defense on the second page, conditions that need repairs. Almost every tenant has some repairs that are needed. So it's very often accurate to check that, and that's good to do for a couple of reasons. One, they're entitled to have those repairs made. And even if they're leaving the apartment soon, they're entitled to have heat or no mold or whatever it is, as long as they're there. And secondly, it sort of balances the scales of justice a little bit. The landlord is not necessarily perceived as the good guy if there's bad conditions in the apartment that they haven't corrected. So when there are repairs needed, it's helpful if the tenant wants to get the repair to check that box.
Can we skip to the next slide? Okay. And I think that's Angie.
Yes, hello. Okay, so seeking a stay in a non-payment case, fancy way of saying seeking a stop. A legal stay is literally just like a temporary stop to this case, which you could ask for a number of reasons that Sarah discussed. Maybe you need some more time to make a payment or to get your applications into different rental assistance programs. So usually the first order to show cause is granted in a non-payment case, particularly if you are showing proof that you are putting a plan into action. You're putting in your application into the one-shot deal. You're calling charities. You're getting in touch with home base to see if you can get a voucher. So when I'm at the table and I'm helping folks out with an order to show cause, I always like to tell them, assume that the court knows nothing and won't believe anything you say. So you want to come ready with that proof. Come with printed documents. Printed is always best. You don't know if the judge is going to look at your phone if you show them a screenshot. So one of the issues that we have at courts is the copy machines. Come ready with that proof printed out ahead of time. When you're explaining, what's going on in your order to show cause. You want to be very clear. I applied to the one-shot deal. If you have a date, put that date. I'm waiting for a response. My application is pending. I've called such and such places. Name the places. Be very specific, because I find that when we're specific, they tend to believe more that you're actually doing these things, because it sounds like you know what you're talking about. And yes, if there is an agency delay, if you've been waiting several months for the one-shot deal, that's pretty common, unfortunately. So you want to explain that very clearly. Unfortunately, something that happens a lot is that folks will not upload a document, or something gets missed out. HRA, they're people too, sometimes certain things don't get through. And there are delays. And so folks have to reapply for the one-shot deal. I think Sarah was telling me about her experiences having to do that as well. It happens to even those of us who work within housing. So you always want to explain clearly what's going on step by step.
Okay, all right.
Oh, and just one other thing I thought. So agency delay, there's the one-shot deal, but also sometimes if you have a voucher involved with your apartment, that's just another agency that you're interacting with in order to either pay back rent or to pay your current rent. And it can be very complicated. In Brooklyn, there's a pilot program that helps people deal with voucher paperwork issues, but that's not available in other courts. So if there is any government agency whose issues have contributed to you missing a deadline, you might as well bring it up.
Yeah, if you can get those agencies to maybe write a letter, like, and maybe I don't think HRA does it. You just go online to the HRA access, or you get like a printout HRA that says pending. But other agencies like Homebase, they may write a letter saying, hey, we're still processing the case. So if you can get that letter, that's great. Attach it to your order to show cause. And also, the courts will keep every single document that you submit. Do not bring originals. Make copies, because you're not going to get those back. So sometimes people like submit their original documents of like maybe a proof that they made the payment, and then they're like, I don't have it anymore. Yeah, don't do that. Make copies. Again, like Andrew said, copy machines may be broken. Go make the copies elsewhere, have it printed out. There's no printing machine in housing court. There's copy machines. There's no printing machine. So have it ready to go. Assume the courts are not providing you anything. They don't provide you pens. Bring a pen. We sometimes have pens, but we're not always there. Okay. So I think we're not doing this run, right? Yeah. Yeah, sorry, that was my error.
Yeah,
I
I think
think
Nipa, this one is you, right?
no, vacate judgment to failure. That's you, Angie.
Yes, that's me. Sorry. Let me just orient myself. Okay, so going into another order to show cause, lots of legal terms again. Do not be scared. Everything is Googleable. Vacate means to remove, to annul, to cancel. So you're trying to cancel a decision that the judge made, so that you have an opportunity to come to court and, for example, request more time to pay or request more time to stay in an apartment. So in this order to show cause, we see that it was granted because there's a court date. It says here March 6, 2024. And then we also see at the bottom of the first page, I don't know if you guys can look at that or zoom in on your Zoom, but it tells you how to serve the paperwork. So just something to make sure you're really looking into detail when you do an order to show cause. You're supposed to serve the order to the attorney or the landlord if they're representing themselves, and then also to the marshal if there is a marshal. And the judge will explain how to do the service. So for example, here, the judge asks that the other party be served by first-class mail with certificate of mailing at the post office. That's the white slip. There's a big difference between first class mail and certified mail, which is the green slip. And if you're ever in these situations, those things do matter. And they specifically ask them to do it on or before February 21st, 2024. And then they're also asking the tenant to serve the marshal by first class mail. So just wanted to mention that because as we move forward, you're going to see that in every order to show cause. So in this one, the tenant, I'm going to zoom in a little bit, is explaining in number 3 on the second page that a judgment was, oh, yes,
Sorry,
go ahead.
Angie, I just want to go back. It says also, if you look closely, it says or by personal service and hand delivery or by first class mail. So you have either options. And then I don't know if Kenny, if you want to just jump in, it says in court okay also, what that essentially
Yeah,
means.
that means the attorney. So this is Gutman and Mintz. They're in almost every borough. They're in court every day. So the judge is saying you could serve them in court if you can find them.
Oh, great. Okay.
I'll have more to say in a minute, but keep going. Yep.
Awesome. Great. Yes. So going back to the second page, number 3, this tenant circled that a judgment was entered after a stipulation. So an agreement that they came to with a landlord or their attorney, because they failed to comply with the order of the court. So they were not able to meet the terms of the agreement. So they explained here that they made a $4,000 a month payment, but didn't understand that current rent wasn't included in the $4,000. They need more time to get the money together. In number 4, they kind of go into details. They explain that they've made payments and they were late on the last one. They've paid a total of $11,365, and they believe that the balance is now $7,000. This may sound silly, but if you have more to say in an order to show cause, at the tables, we usually draw a little arrow to the bottom of the page so that we can keep writing. You can do that, and you don't have to write everything in 2 lines. And they mentioned that they actually were approved for ERAP, and they believe that a portion of the ERAP payment that was granted to them isn't being counted in this. So what's great about this order to show cause, again, they're very specific with the numbers. They know exactly what they've paid off. They know what's left behind. They're explaining the reason they weren't able to make the payment on time. So what happens oftentimes is that folks don't understand that the payments that they have to make in a stipulation is a payment in addition to having to keep up with current rent. I believe we have another workshop that goes into this further, just how to read a stipulation, and you guys can check that out on our YouTube page. But yes, you want to make sure that you're explaining clearly why you weren't able to comply, what you're doing to comply in the future, what your plan is to comply. This one's a little different because they're also bringing up ERAP, but it is an opportunity to bring up other defenses. I believe this tenant had attached proof of payments. We don't see it here, but what would be great in a situation like this is to show the payment. Maybe you paid on Zelle, maybe you wrote out a check, make a copy of that and attach it to the order to show cause.
Yeah, so I just wanted to add a few quick things. One is that at the very top of the first page, it says order to show cause to vacate a judgment based on failure to comply with a stipulation. And then you see from the second page that the tenant signed the stipulation, which is another word for an agreement that you sign in court. The judge signs it. It's a contract. And usually, and if the tenant's pro se and they're in a non-payment case, they'll consent to a judgment and a warrant with time to pay. So the types of court papers, so you understand the process, the first thing that starts it is called a petition. Then if you make an agreement, that's a stipulation. The stipulation may include consenting to a judgment and a warrant. A warrant is what allows a marshal to evict. And the very last thing before that is called a marshal's notice or a notice of eviction. So this document is really mislabeled. You're not really trying to vacate the judgment. You just want more time to satisfy the judgment. Not complying with an agreement is not a reason to vacate the agreement. If you make an agreement, you can't just decide not to keep it. So you're not really seeking to vacate the judgment. You're asking to modify the agreement. I just want to point that out. Second very important thing where it says you could serve the marshal either by personal delivery in hand by going to their office, or you could mail it to them. So a marshal serves a notice. It's a 14-day notice. that the eviction could take place on or after the 14th day after. So if a notice is served today and dated May 10th, the first eviction, the earliest eviction date is 14 days from Monday the 13th, which would be May 27th. So if you're in court on May 26th with an order to show cause, the eviction could take place the next day. And even if you call the marshal and they tell you it's not scheduled the next day, they're legally allowed to change that up until 4 o'clock and schedule it for the next day. My point only is you don't want to mail it if it's scheduled, might be scheduled the next day. So if it could be scheduled the next day, you want to make sure the marshal actually receives it before the earliest eviction date. Because if you mail it, that doesn't stop the eviction till they get it.
Okay, I was just wondering, like, if you, because the it says hand deliver in court, if they wanted to, make the argument that they never actually delivered, how would you, if you gave it to the other attorney in court, how would you get proof that you actually did?
So you would ask them to sign it.
Mm-hmm.
Normally they'll sign your copy. If they don't sign it, you're going to have to do an affidavit, just which gets pretty complicated for someone without a lawyer. So it's risky. So if they won't sign for it, then they should mail it too and keep the certificate of mailing, which is proof that they did serve it.
Mm-hmm. Yeah, I just wanted to point that out because you need proof.
Right.
With the certificate of mailing, you have the proof that you did.
Right.
If you hand it in person, and again, one thing I want to point out is that sometimes, like with tenants, we get a call, like I told them this, but remember, the landlord's already taken you to court, or the landlord's attorney. They could say one thing to you over the phone and do completely something else in court. So you always need to, cover yourself. So everything should be in a way that's trackable. And then we have another example. Angie's gonna take over.
Yes, thank you, Kenny. Great. Thank you for explaining like the timing of when to do it as well with reference to a marshal's notice, because that's the situation that we have here. If you look at the second page, this person is explaining that they received a 14-day eviction notice. So remember, the marshal doesn't just come. They always leave a notice on the door. And it says here, the eviction day notice, they received it on January 6th. They were present in their landlord's office on the 8th with the check. And then further down, they explained on the 8th, they provided a check for around $13,000 to their property management that was not accepted on the 9th. They provided a cashier's check for the same amount, covering the entire back rent owed. So it looks like this tenant was actually able to comply with their agreement, with their stipulation, but the check wasn't accepted. So in this situation, again, this tenant, maybe they did, but we just don't have a picture of it, but is going to want to provide proof that they did send out a check. So a copy of the check would suffice for that. Or they could bring that check to court on their scheduled court date, which it looks like the judge gave them, looks like January 29th at 9:30. So when they come in, they can bring that check in. So you can also, maybe somebody will mention this later on, but sometimes when you're like down on the time crunch, you don't have time to get proof of things, you can write on the order to show cause, hey, I'm going to bring a check in for such and such amount at the next court date if you give me the opportunity to come in. But then you absolutely need to come in with that check if you're going to say that.
Well, also that's better. Also better in a situation where you don't have the money yet. If you have it, say I'll bring it to you. I'll show it to you later. It's not nearly as good. So it's worth attaching. That makes such a big difference if you can attach the check rather than say take my word for it. Because judges think with a marshal coming, people are desperate. They'll say anything, so they want to see proof. But if you don't have the money, but you're going to get paid, on the thing, I'll say, I get paid on the 15th, and I'll bring X amount of money on the return date as a second best thing to attaching a check if you can't do that.
Right, exactly.
And sometimes the judge will hear that, and then sometimes on the order to show cause, they might actually say, on return date, bring XYZ.
Mm-hmm.
Right. bring money order, bring signed document, whatever it is that you said, they'll put a reminder, bring this.
Right. And also like same thing with if you get are someone who receives Social Security, retirement, those are payments are only made like once a month. So if you can't make the payment by the deadline because you haven't paid yet, write that down. Social Security will pay on this date, and that's when I can make the payment. The more specific you get, the more believable it becomes, as opposed to I'm going to make a payment. That sometimes we see that, okay, but that's not very believable. How much is the payment? When are you going to make the payment? That's what helped in this specific scenario because she wrote a very specific detailed payment, things like that. Also, sometimes like Angie was saying, like broken copy machines, if you don't and you can't find one near you. I know with like, tech, everything's like on your phone, it gets harder and harder to find copy machines nearby. Write the check number. This is the check number. The more detail you come, the more believable it becomes. Like, think of the judge as like not your friend, but like if someone was telling you this scenario, would you believe them? Should I move on, Angie? Okay, great. So a lot of those the order show causes we went into were most of them were like for non-payment cases. So now we're gonna go into examples of where they were used in a holdover. So a holdover is a type of case. There's two types of cases that a landlord can file in court. Non-payment, which is you pay the rent. It's all about getting the back rent that's owed. Holdover, it means they want you out. Regardless of whether you pay a rent, you have to leave. Now, depending on the type of apartment you live in, you may have defenses, especially if it's rent regulated. The good cause eviction that just passed made some changes, and we actually are having a training about that next Friday, so feel free to register. But in a holdover case, the courts can give up to 1 year from the date of judgment under the HSTPA rulings of 2019 to give you time to move. Now, the key word is up to 1 year. It's not everybody is going to get 1 year. Don't assume you're going to get 1 year. You need to be very organized. You need to provide proof of that, but they can give up to 1 year. Now, so what that means is that maybe you have a deadline to move and now you need an extension essentially. When you're requesting that type of extension, essentially, these are you need to provide certain proofs. You need to give the judge a reason to want to give you time, essentially. So you need to describe and document efforts to relocate. So when you're searching for housing, whether it's a Craigslist ad, whether it's like, something you saw on the internet, a sign on the door, maybe like a for rent sign, you're working with a real estate agent. Every time, you search for an apartment, write that down. Date, time, a housing log, keep that. That is proof. People may not think of it as proof, but that is proof. Write down the address, the number you called, the date you called. Bring up sympathetic factors. The one thing I want to point out about sympathetic factors, it's not just the sympathetic factors, it's in addition to the other proof. Only the sympathetic factors most likely will not get you that extra time in itself. You need to show proof that you're attempting to relocate in addition to the sympathetic factors. So children in school is a great example. I am looking to relocate, but my children are in school and it'll be an extreme hindrance to the children if they were forced to move out mid-school year. Judges do not like to interrupt education, so that is a great reason, but you still need to show that you're making the effort to relocate. If you have an illness, maybe you're scheduled for surgery, maybe you have ongoing treatment. Judge, it's not that you don't have to move. You still have to move. It's just you're wanting extra time to move so that you can, deal with the current immediate situation, which is your illness and you're scheduled for surgery and cannot move right now because you need time to heal, things like that. So you can't go out to look for an apartment. So bring proof of that. If you have a letter from the doctor's appointment, everybody should be able to get, a letter from their doctor with the schedule, even if it doesn't say the specific, hey, like come scheduled for surgery, it should say, I have an appointment. Everybody should be able to get that. Those are the type of sympathetic factors. If ability to pay for more time. Sometimes what people will do, they will say, most of the time you're going to be ordered to pay something called use and occupancy, which is even though you don't have a lease or anything like that, while you're living there, you have to pay. So if you can show that you've been paying and you're willing to pay while you're still living there, essentially that I've been looking for an apartment, I haven't found it, but I have been paying the rent. That might sway a judge to give you more time because it's in a sense not hindering the landlord, and you're doing your part and you're showing that I'm paying, and attach copies of the money orders. If the landlord doesn't accept it, attach copies of the proof that, hey, this is the money I can pay, I just need more time. But again, also show the proof that you're looking to relocate, that you're not just not looking. I think, Kenny, did you want to add some things?
Yeah, back up to the previous slide for a second. So don't be fooled by this. This is part of the wonderful law that was passed in 2019, the Housing Stability and Tenant Protection Act, HSTPA. And it said that if someone's lease expires, this is pre-good cause, where there are much more protections, or if people who aren't covered. Your lease is up, the landlord gives you a notice saying you have to leave. You go to court, you agree to leave. The court can give up to a year from that date, but they're not going to. It's very, very rare that people will get that. I mean, a situation maybe where a bank got a building post foreclosure, a family's lived there for decades, and they lost the building, and they're elderly and sick, and it's just a bank, and they could pay for the additional time, maybe, and they keep coming back bit by bit. They might get as close to a year, but what the reality is that if it's a holdover, even though, and this law says they don't need to have a new place to go, they just need to show that they've made reasonable efforts to find another apartment. We all know there's hardly any affordable housing out there, so it's not that hard to show you looked, and guess what? You couldn't find anything. That should be enough for the court to give you more time, but in reality, it's not. The second, they might give you one extension. Every judge is different. And again, they're not always consistent, even with themselves. But many judges will want some proof, some indication of that there's a place to leave if you bring a second order to show cause, as we said in the next slide. Sympathetic factors, back to the next slide. Sympathetic factors, also things like SCREE and DREE, or Social Security, just little things to humanize it to the judge, to make them want to extend themselves on the tenant's behalf.
The one other thing I want to point out is that there are sympathetic factors. I think one thing tenants don't get into the mindset of is that, judges, you need proof as the most important factor, because judges are hearing these type of cases, hundreds of these cases every week. They've heard it all. You may, unfortunately, you're not thinking yes, your story is unfortunately, hard, and, it is sad what you're going through, but they're hearing these cases all the time. So they're not going to automatically believe you necessarily. So proof is the most important thing. Yeah. And then we're back to Angie.
Hi. Sorry. Okay. So we're looking at an order to show cause to restore to the calendar. Fancy way of saying is I'm requesting a court date. I want to come back in. Sometimes folks want to come in before they have a scheduled court date because they've agreed to a stipulation and they only have a couple of days left to comply and they know they're not going to. So I actually personally helped this client in Queens. She was in a holdover case where she came to an agreement with her landlord. And if you look at the second page, she mentions that I helped her write this. So I wrote that I cannot move before February 28th, as stipulated unless the landlord complies. And this was a situation where the agreement was that the landlord was going to pay first month rent and security deposit for a new apartment. If the tenant could find an apartment to move into before the 28th. The tenant had, she states here, I found an apartment in Brooklyn. She attached her proof of that, of her communications with the real estate agent. She even says how much the rent is. It's $16.85 a month. The landlord is refusing to pay the first month's rent and security deposit. And so she came to court to request that the landlord comply so that she could actually move into this apartment. And this was approved. This tenant actually was very proactive. She came ready. She had never spoken to us before. And she brought pages and pages of like all of the places that she had looked at, and finally the apartment and the agreement that she had made with the realtor to move into this apartment. So yes, this was granted, and I believe she was able to move. What's interesting about this particular order to show cause is the service, and everybody else can step in if I'm not able to explain this well. But the judge actually said that filing to NICEF constitutes a service for this OSC. So she actually didn't need to serve it to the attorney. And then she just had to let the marshal know by personal service or by first class mail by the 23rd.
So for people don't know NICEF, so the court during COVID pretty much switched to almost completely electronic filing. Any case that a landlord's lawyer brings has to be done through the electronic filing of the New York State courts. If there's two attorneys, they both have to participate in it. If either side doesn't have a lawyer, they have the option of still using paper. So this case was started by Novak Edelstein, one of the big landlord firms. So the judge, after Judge Sanchez signs the order to show cause, she's going to put it on NICEF, on the computer court system, and the lawyer automatically gets notified. They don't have to look; they'll get an email. So she's saying that's good enough service on that. Again, with the marshal, you don't want to mail it if the eviction could take place, in the next week.
Right. And on this one, I believe she had by the 28th, and in the stipulation, it said that if she did not comply, she could then be served with the marshal's notice. So this tenant was trying to delay the marshal coming in. But like Kenny explained, like if something crosses over, you want to make sure you serve the marshal to prevent that from happening. So. Okay, I believe I have the next slide as well.
Can I just point out one thing on this? So we, as people who work within the court system, have become experts in handwriting. If you don't understand something, and frequently it happens, ask right away. Like look at the paperwork. Usually it's the court clerk speaking to you, which is the judge's assistant. Most of the time, the judge is not the one directly speaking to you. They'll explain it. If you don't understand, ask them, what does it say? Write it down yourself. Because yeah, it's frequently true that you're not able to read it, but we're able to read it because yeah, we've gotten used to it. If you don't understand, ask the person who's issuing the decision. Who's gonna know better than the person is issuing the decision what they want. Yeah. So just make sure you have a clear understanding before you leave the courtroom what you're supposed to do in terms of the serving process.
Just to add to what Angie said. So there's really 4 different people in the courtroom working for the court. There's the judge, there's the judge's court attorney, there's a clerk who's not an attorney, but they just keep track of the records, and then there's a court officer. So depending on the judge, it could be any one of those 4 that comes out with the paper if it's signed that you can ask your questions of.
Okay. Great. So here's another example. Okay, so I feel like we've gone into depth about the service. If you guys have questions in the end, you want to go into more details, then we absolutely can. So in this one, I think it was also a holdover. So the tenant wrote that a judgment was entered after the stipulation and failed to comply because she needs more time to finalize her new apartment arrangement. She's applied to many apartments, see proof attached, but when I bring up my newborn, they say no. And then in number 4, she explains that she was able to get a City FEPS voucher to move, and she's been finding listings that accept City FEPS. She needs more time to secure an apartment. And then what's nice about this one is that she also mentions that there are conditions in the apartment that need repair. So again, you can mention those things. If you look at the different options that you have, they give you some like options that you can check off, but then you also have the 2 lines to write into details. So I'm going to assume that this tenant had also attached proof of the voucher since they had attached proof of the apartments they were looking at. But what's great is she's explaining why she wasn't able to comply. She's going into details like she has a newborn. It's hard to find a child, but she has been proactive. She got a City FEPS vouchers. She's looking at different listings. She has a list of the listings. So when people are in holdovers, we usually recommend that they keep track. And I think Nipa mentioned this before as well. But just to reiterate, if you don't have communications with realtors, like emails that you can print out, you can make your own list. Like worst case scenario, just try your best to prove that you are looking. And this person had made a list of the places that they were looking at, and that's why this one was approved. Okay. All right. And moving on to the next one. So this order to show cause was actually denied. And I'm just zooming in on my end. Okay, so the judge will sometimes tell you what next steps you need to take or the reason why you were denied or how you should reapply for an order to show cause if it is denied. So here, the judge stated that per stip to vacate with waiver, no good cause to stay. So they're saying that the tenant didn't provide a good enough reason to get an extension on the time. And we're going to go into what makes this not a very, like a weak order to show cause. So the tenant wrote debilitating thyroid, unforeseeable circumstances, willing to compensate rent within reason. And then they wrote again, unforeseeable medical hardship. So while sympathetic reasons can be used in an order to show cause, it can't be the only thing that you mention. Again, you have to give proof as to what you're doing to move in this case, since this is a holdover. And if you are going to bring up sympathetic reasons, we always recommend that when it comes, for example, to medical reasons, that you bring proof of that you bring proof of a diagnosis, a doctor's letter. If you're scheduled for surgery, bring that. And this order to show cause also doesn't show any effort to find a new place. So while they are saying that, they're not doing well right now, they're not saying what they're doing to look for a new apartment. So this order to show cause would have benefited from some type of proof that they've been proactively looking for apartments.
Oh, Kenny, you're muted.
Also, if you look at the top of the first page, you can see it's the tenant's 3rd order to show cause, meaning they made an agreement, didn't keep it, got more time, didn't keep that, got more time, didn't keep that. So, the more orders to show cause, again, the less likely it is that you're going to get it signed. So you really need to put as much into it and also realize that there's a good chance it won't be signed and hope for the best and prepare for the worst.
Yeah, I just want to add on that, like, when you provide medical documentations in court, sometimes if the medical documentations you're trying to add on to the case are too detailed, courts, these documents are all public documents. So we did not, these aren't just like cases we did, these are pulled off from NICEF, which is the online system that court to file cases. Everybody can see it, and anybody who knows how to use it can run the record. If you're providing medical documentation, you want to black out parts. Like, you can just take a pen and like black out the parts. You don't have to go into like use a system like we did. You can black out parts that provide like detail. Like some people, if you're familiar with HASA, that's a voucher that's for people with HIV/AIDS. And, you don't even have to write. There's ways to go up in front of the judge to say like, hey, not for order to show cause, but there's ways to write medical condition without specifically stating that. In this situation, they said debilitating thyroid, but they didn't explain how it's debilitating. So you can't just write medical condition. Like some things are like self-explanatory. I'm going through chemotherapy. Okay, that's self-explanatory. But if you just say I have a thyroid condition, what about is debilitating? Because a lot of people have medical illnesses, but it's not necessarily debilitating, which is the key word. How to prevent you from looking for an apartment. Yeah, and also if you're providing medical documentation, again, like just blackout parts, some court clerks will not accept those documents and they will actually give it back to you because they have an obligation to make sure that your medical information is not revealed to the public. I don't know if you want to just speak on it a little bit, Kenny.
No, I don't. I think you said it. Just also social security numbers should be redacted as well. Identity theft is still a big problem.
Okay, great. And I think we move on to the next one.
Mhm.
Okay.
I use the word redacted. That means when you submit a document, but you block some of it out with a black magic marker or whatever, so that it can't be read. That's called redact.
Right. Okay. So, yeah. So this is an example of an order show cause to vacate inquest judgment. So to understand it, you need to know what an inquest judgment is. When a holdover case is filed, it comes with a court date. So non-payment cases don't come with a court date. You have to go in to answer. Holdover cases come with a court date. Now, if someone doesn't appear for that court date, nobody appears, then they have to schedule sort of like a mini trial before the judge can do a default judgment, essentially. Basically, they have to see that the landlord is actually the owner of this property and that they served the paperwork correctly. So that will take place. And then the judge will allow like the default judgments to go through because nobody showed up. So if that happens, what this order shall cause is to vacate, so cancel that inquest judgment, essentially. So in this situation, the person, what they did is they're actually claiming that they are the roommate of the leaseholder. So the things they had to explain is they're requesting more time. So I'm asking for more time to say while I secure housing for me and my unborn child, due date October 31st. So that's great that she put down the specific date. She didn't have to put down the like October 31st. She could have just put October 2024, but if she feels comfortable, that's fine. Again, these are public documents. And she explains like her plan. So it's the sympathetic factor plus her plan to, resolve the situation. So she has a shopping letter for City FEPS. For anybody who doesn't know, City FEPS is a voucher program that helps you pay for an apartment. So she has a letter that is going to help her pay for an apartment. She's just looking for the apartment. And then she actually she has a real estate agent, and then the blacked out part is because she provided the name and phone number of the real estate agent she's working with. So that's great that she goes into specific detail. What I think would have also helped, and the details of how she's planning to resolve the arrears. I mean, resolve, not the arrears, like how she's planning to resolve this housing situation is what led to essentially the approval, because the judge did approve it. Also, if anybody's like, if you're confused of whether you're approved, if you get an upcoming court date, you've been approved. If otherwise it'll say deny, but just in case, so it's great that she put those. What is helpful also for anybody who's trying to vacate an inquest judgment, it would have been more helpful if she also said, hey, the reason I didn't show up to the court case, we don't know the reason. Maybe she had a medical emergency, maybe, she's pregnant. I can't just assume the reason. So I'm not going to say why, but if you didn't know about it, frequently in like a roommate situation, a lot of times, people don't have access to the mailbox. The main tenant may hide the mail from them. They don't want to let them know. that, hey, there's a housing court case going on, things like that. So if you didn't know, you would want to explain that. I didn't appear because I didn't know about this court case. And then she should have, I believe, if I'm wrong, Kenny, put her initials next to 3, excuse, a judgment. No, wait.
Yeah.
Yeah.
Let me check right there.
Number 3, she should have like put her initials there, but the remaining like reasons she provided was strong enough that, you know, the judge didn't hold that too much against her. But this is a great example of that. Yeah, so here it's or she has to also serve the marshal and on or before the due date. So everybody wants to check, be very careful when looking at this. Sometimes it'll be the same date, like the date you go into court. Like if you go in the morning, the date on here, it could be the same date. Like you need to serve it by before today. So you really want to look at that deadline, because if you miss this deadline on the upcoming court date, what happens is that the landlord, the other side, they can argue that, hey, you didn't follow the instructions that the court set out. So this request should be canceled based on the fact that you essentially didn't follow the instructions. So it's very important to follow those instructions as provided. Also, tenants, sometimes they get the approval, but they don't realize they have a court date. So when you're requesting an order to show cause in housing court within New York City, you're approved, you're always going to have a follow-up court date. You have to appear on that court date. It's not a great look if you miss that court date because you're the one who requested this. So unless there's emergencies, like if you're running late, frequently, like people will have that. They're running late because they dropped their children off to school and their appointment is at 9:30. So their name was called and now they missed it. Now they have to do another one. If you want to know how many orders show causes, you look up here where it says number of response or show approved and sequence. So it's a sequence 2. So that's the amount of order show cause have been requested. Every time that number goes up, it gets harder and harder to get that request granted. Particularly with clients without attorneys. They are going to have a very different experience, unfortunately, whether it's right or wrong. The reality is that they're going to have a different experience than people with attorneys. So make sure if they give you a court date at 9:30, maybe right then and there. Sometimes it works, sometimes it doesn't. Just let them know, like, hey, 9:30, is there any way we could do it in a later time? Because I have to drop off the kids at school. Sometimes they'll change it, sometimes they won't, but it never hurts to ask. Yeah.
Yeah, a couple of quick points. One thing, so a default, whether it's a non-payment that you didn't answer or missed a court date, or a holdover where you missed the court date, it results in a judgment. And that judgment then has the same effect as if you did come to court and you made an agreement. So in either case, if you're asking for more time, you don't necessarily need to undo the agreement. You just need to modify it to give you more time. Same thing as if you defaulted, as in this case, you don't necessarily have to undo the default and undo the judgment. You just could get more time to satisfy the judgment. That's easier for the judge to do than to go backwards to the beginning of the case, which is harder for them to justify. Most of the judges want to appear fair to the landlord and the tenant, even though their interests are so different, property rights versus human rights and all that. But that's what the judge's mindset usually is. So again, that's the reason why you don't want to miss a court date on an order to show cause. The judge will feel, hey, I gave you a chance. You got an extra month. You didn't show up. You're putting me in a bad spot here to do it again. So yeah, it's really important that people be there on time for their return dates. But I really like the fact that the due date was specified. It makes it much easier for the judge to feel it than if you say I'm 8 months pregnant, but a due date, that's much more vivid, and it just tugs at the judge's heartstrings a little.
I forgot to I just want to go back to this one for a quick second. So even though this was used in a holdover, you can actually use the same type of order show cause also in a non-payment case if the landlord is not giving you the required documents to get assistance. So let's say you are trying to, if you're applying for a one-shot deal, and you need the rent breakdown and the landlord or the landlord's attorney is refusing to give it and your case is going to be closed out. You can use this to restore to the calendar and let the judge know, I've been trying to get the money, but the landlord has been refusing to give the rent breakdown needed. I've seen people use this before.
Yeah, that's
Go ahead.
that's very important to say. And often that's the only thing holding it up. And that's useful. There was a different one we saw a little while ago where the landlord wasn't paying the first month's rent, so they couldn't move. Many agreements that tenants sign, they'll get money after they leave. That's the way it's written. And so therefore they're not going to get the money before they leave, even if they needed to leave. So that's a separate thing about writing stipulations, which we can get into in a different training. But basically, tenants often don't realize that if it says you'll get it when they leave, that's what it means. But they could still ask the court to release the money early so that they can move if they have proof from the new place that they need an X amount of money to move, and everyone wants them to move. That's could be possible.
Right. Thanks for that. Yeah, and you're just gonna have to specify here why you're asking like, hey, I've been trying to get I need a rent breakdown. I applied for it. I'm trying to comply with the stip, but the landlord is not. So hopefully a judge will order the landlord. Like frequently I hear tenants say, they know about it. They know about it, but they're hearing it from me versus like a court order. Does make a little bit of a difference when there's an order.
Right. And if you have an agency letter, either from home base or welfare saying, yeah, we need a landlord breakdown, make a copy of that, circle that as one of your exhibits, and then put in the affidavit that I need a breakdown, see attached, and they refuse to give it. Make it easy for the judge to see it your way.
Yeah. And then, yeah. Also, one thing I want to point out, going back to the vacate inquest judgment, I want to point out her handwriting. Judges are human. If you have really sloppy handwriting and people are in a rush, they're panicking, it's not a judgment on you, but think about it, put yourself in the situation. If you get something and it's barely legible, yes, the court staff, their writing is barely legible, but they're the people with the power. You unfortunately are not. Make it legible, easy for them to read, because depending on their mood, they could be like, I don't understand this. They have a lot of sway. They have a lot of discretion power. So try to make it as readable as possible. We're not saying it has to be like perfect, but it shouldn't be, chicken scratch.
Absolutely. And as I said just a minute ago about attaching the thing needing a breakdown, make it easy for the judge. So this falls under that category.
So now we're going to get into post-evict order show cause. Unfortunately, the reality is that some people are evicted. Now, once you are evicted, you still have an opportunity to try and get back into the apartment. These things have to happen very quickly. There's a limited amount of time you have to get back into the apartment. So this is called a post-evict order show cause. When you're gonna do a post-evict order show cause, there's specific things that you are asking for. So if you're saying that the eviction procedure was wrong, you have to specify why the reason the eviction was wrong. You have to bring up sympathetic factors, but again, sympathetic factors in itself want to emphasize in itself only is not a reason to get back in the apartment. It's even 10 times harder once you've been evicted. Assume once you've been evicted that a decision has been made already because you've been evicted. Now you're just trying to reverse that decision in a sense, but it gets 10 times harder. So most of the time when you're doing a post-evict order shall cause, what you're asking for is a stay on re-renting the apartment. What that means is that you've been evicted. The landlord now wants to rent that apartment. They want their money. So, because you no longer have an obligation to necessarily pay the rent because an eviction has occurred. So they want somebody else to pay rent at the apartment right now. You want to stop the landlord. You want a court order saying that the landlord should not re-rent the apartments for a specified amount of time so I can get some time to get, things together. So frequently in a non-payment case, what that means that when you've been evicted in a non-payment case, you need to pay legal, late, and marshal's fees before you can be evicted. So prior to an eviction, you need to just pay the arrears. And once you've been evicted, legal, late, and marshal's fees. So you want to stop the landlord. You're asking the courts to order the landlord to not rent the apartment to somebody else while you work on that. If somebody takes over the apartment, and I've seen those type of situations because people waited too long, a judge is not frequently not going to go ahead and evict somebody else so that you can get back into the apartment. They don't want to do more evictions. Yeah. So that's when it says access state. You have to be very clear about that. Request access for medicine, clothes, documents, and other personal belongings. So even though you've been evicted, what you can do is ask the judge, and they're pretty easy about like giving you access. Hey, I want just a couple of hours to go in to get some belongings. Because most time when people know an eviction is coming, unfortunately, sometimes, they go to the supermarket and then the marshal just comes in during that time. And now they only have the clothes that they're wearing. So you want access to get maybe like your belongings, like documents like social security cards, credit cards, debit cards, some clothes, some medicine, things like that. So the sympathetic factor is like, I really need to get these stuff. Because I'm a cancer patient, I need to get this access as soon as possible. When you're asking for the access, try to get it in a way that's very detailed access. So let's say you were evicted today and on the order it says May 10th. It doesn't specify a time. It'd be helpful to have a time because frequently what happens is the landlord is trying to delay in giving you access. They'll be like, yeah, I'll be there in 2 hours. There's another day. I'll be in there another 2 hours. Things like that do happen. If you have a specified amount of time written, like let's say it's May 10th from 2 to 4 p.m., landlord, you have to give access to the tenant to go in there to get belongings. What that means, it doesn't mean, I want to be very clear. Requesting access doesn't mean you are now allowed to stay in your apartment. It just means you go in there to get some stuff and get out at the same time. But if it's like 2 to 4 p.m. and the landlord is not there, what you can do is you can call the police, and the police can enforce like a court order. They are there, so they can enforce that court order. Yeah, those are the type of things that you're asking. But yeah, you have to specify that in the order to show cause, and we will see, I think,
If I could just a word on this. So a post-evict order to show cause means there's already been a court case. And one way or another, a judgment was entered, either by stipulation, trial, or on default. So you need to address the prior history, like what happened in this case that came about that you got evicted. You need to explain that because the judge is going to look at the file and know that. So if you missed the court date, why'd you miss the court date? Anyway, you need to put in stuff relevant to the specific facts of what happened in this case. This is the different from an illegal lockout where there's no court case and the landlord locks you out. That's a crime, and that's a different kind of case. You can bring an order to show cause for a lockout. That's not what we're talking about in this situation.
Yeah, and I just want to.
Oh, no, I was just going to say, just as a time check, we've only got like 25 minutes left. So just putting that out there. And we've got an example of this. Maybe it'd be helpful to like look at the example.
Yeah.
Okay. Yeah, so for this example, we can see the title of it is Restore to Possession, meaning like right now the landlord has possession, like legal possession of the apartment, and the tenant is hoping to get it back. right? If we look at this first page, it looks a little different, right? It says a few things that the judge has ordered. The judge has ordered that the landlord can't relet or re-rent the apartment until this order to show cause is dealt with. The return date is March 8th. Let's see. The landlord is stayed or prevented from removing the tenant's possessions from the apartment. We don't see any access dates, some interim access dates. That's a thing that a tenant, like Nipa said, can ask for. We don't see anything here regarding that. Also, the service looks a little bit different. The judge says that it is enough for the landlord's lawyer to be notified using the online system. The tenant is not expected to serve the document. Let's see. Marshall stuff isn't checked. Let's see, but going over to the next page, the document that the tenant filled out, they explain in part 1, they're the tenant. Part 2, or section 2, the defense, they explain how they came to be locked out, right? They say the marshal locked me out of the apartment today. Again, they give a date that's specific. I never received a marshal's notice to warn me. If I had received a notice, I would have come to court immediately to do an order to show cause. You know, here the tenant is demonstrating like, oh, I am a person who takes court seriously. I wasn't just ignoring things. We're trying to, show that, get the judge to see them in a particular way. Now, if even maybe the marshal's notice didn't come properly, maybe it got lost in the mail, maybe it went in the mailbox, but there's something wrong with the mailbox. We don't know, but it does mean that there was a deadline missed or something happened, right? Because this is order to show cause too. So it's not like the tenant didn't know about this case. So if there was a deadline that was missed, even if the marshal's notice hasn't come yet, but if you know the marshal's notice could come, it's a good idea to go to court. It's a good idea to call housing court answers. We can look in the case file. We could find out the marshal's phone number. So you can call them and say, hey, have you guys come to deliver a notice? I haven't seen anything. Are you coming to deliver a notice? We can look to see if the warrant has gone active or not. So when you've missed a deadline for whatever reason, if you're not sure about whether you should do an order, call housing court answers and we can help you figure it out, what your next move should be. Okay.
I just want to reemphasize that. Here's someone who got evicted and because she didn't get a marshal's notice, and she said, I assume it's she, that if she had gotten the notice, she would have come to court and explained that she's working with Canva to get the arrears. That happens to people. Do not rely on getting the marshal's notice, because a lot of people don't get the marshal's notice, and being evicted, it's very hard to get back in. Of course, things get, it's a horrible, horrible thing for all people concerned. So again, if the deadline has passed, don't bring that order to show cause, or even before the deadline's passed, because you don't want to get a marshal's notice. It's very disturbing even just to look at it and realize the marshal could come in 2 weeks and change the lock. So before the marshal could even serve the notice, or certainly if the time has come where they could, it's crucial to go, not just a good idea, but really crucial to find out, either call housing court answers to find out what the status is, or just bring that order to show cause saying I'm going to need an extension. So you're not in the position where you might miss a notice and get evicted.
Yeah. And, this person mentioned in her order to show cause that she's been paying rent ever since she signed a stipulation. She was working with Canva on the arrears. This person might have thought, oh, the marshal's not going to come because I've been paying the landlord and they are aware that I'm trying to get the arrears paid. That's trusting the landlord to look out for you, which is not a safe assumption to make. Also, it would be great if this person could provide proof of the recent payments, the proof of the recent rent payments, proof of what they're doing with Canva regarding the arrears. But if she got locked out of her apartment, it might be hard for her to get access to those documents. So it would have been good for her to set up some access dates so she could go get the documents, the money order receipts, letters from Canva. But, you do what you can with what you have where you are.
Also, the judge gave a quick return date from March 6th to March 8th. So they could have given access on March 7th, conceivably. Although serving it on NICEF so the lawyers get an email doesn't mean necessarily that they're going to reach out to their client and arrange access for the following day. But it is always better to request access.
Yeah.
And I just want to say, in extreme situations, you can sometimes ask to be restored to possession immediately. If there's something so outrageous. It's very rare, and especially without a lawyer, it's very rare. But in certain circumstances, it is an option. The judge has the power to say, come back to court next week, and then in the meantime, you can go back to the apartment. It almost never happens, but in the right circumstances, it's not unreasonable to at least ask for it.
Yeah. I would also like to say that he said she could, it's via NICEF, but if she's locked out of her apartment, does she have access to electronics? Sometimes think about those things. So like just make sure you're very clear when you're leaving that, hey, you understand the serving process. She doesn't need to serve the marshal because she's already been evicted. But also the reason she didn't get the access because she didn't write here, I need access. So when we were saying access, like you need to write on here, I want access to get my belongings. You don't ask for it. Don't
That should
assume
be in
the
the
judge.
form. Yeah, that should be in the form.
Yeah. Unfortunately, she didn't request that. So
yeah, there should be a space for that in the form, but there isn't. Yeah.
Yeah. And you have, like Sarah said before, you have space, or I think Angie, you have space. You can write here.
And you can attach additional pages too, if necessary. You don't want it to be too long. You want it to be concise and powerful.
Yeah. Can we move to the next slide?
Yeah.
Okay. When do I request an order to show cause? Like we said, there's so many different kinds of order to show cause. Some of them make sense at the beginning of a case. If this were a repairs case, you would actually be filling out an order to show cause to start the case. If you missed your very first court date, it's kind of the beginning of a case. But as you can see, most of the orders to show cause are things where you're very close to the end, right? There's usually already a judgment in this case. Let's see. So the timing is often about what day does it make the most sense to go do the order to show cause. So if you signed an agreement, this is the last point on this. If you signed an agreement or stipulation agreeing to make a payment or move by a certain date, and the time is about to pass or has already passed, that is a great time. I think we had talked about this earlier. If you are going to miss a work deadline, you might let your boss know 2 weeks in advance that you're not going to be able to make that deadline. If you try to do an order to show cause 2 weeks before you're expected to do something, the judge might tell you it's too early, right? But so if you are ever unsure about the timing of an order to show cause, ask for guidance from Housing Court Answers. You could clear it with the court attorney in the help center at Housing Court. A legal service provider could answer this, because sometimes there is some strategy involved in picking your date for doing an order to show cause.
Yeah, I just want to reframe it a little bit. I mean, the general rule of thumb is the sooner the better. If you miss a court date, don't wait 2 months till you get a marshal's notice. First of all, then you've got a marshal's notice. If you miss a court date, the warrant won't issue right away. So you want to get back to court before the warrant even issues. The judge doesn't like to feel that someone is just stringing it out and playing the game to get delays, but is really aggressively working on the case to get it resolved. So the sooner the better. And I would say if there's a deadline coming up at the end of the month, I would say probably ideally a few days before that is a good time to file it, not afterwards. Now, if someone's got a marshal's notice, you get a marshal's notice dated May 10th, saying the marshal's coming as soon as May 27th, 2 weeks from Monday. You don't want to file it the day before for a couple of reasons. And I'm not sure if there's another slide, but since we're running short
Yeah.
of time and we want to leave time for questions, I want to say, if the judge doesn't sign the order to show cause, if you did it the afternoon before the eviction, you're out of luck. If you file it 3 days before, you have two options. One, you could resubmit it. If the judge says, I want proof of this, proof of efforts to relocate, a copy of the welfare application, copy of money orders, you have time to resubmit it. Secondly, if an order of show cause is not signed by the judge, it's called declined, you can ask the appeals court to sign it, but that takes about a day. So if you do it the afternoon before, you don't have time to get a second bite at the apple by going to the appeals court. So the sooner the better, but at the very worst, at least 3 days before the earliest possible eviction date will give you a second chance if you need it.
Okay. So like I said, for help with the orders to show cause, whether it's, figuring out the timing of it or figuring out what is the smart thing to say when I'm filling out the form, getting help is always a good thing. We have our information tables in housing court everywhere except Staten Island. We're usually there Monday through Thursday, so maybe don't wait until Friday. Try to do it Monday to Thursday, especially if you think that this is going to be tricky to explain. But also Monday through Friday, we have our hotline and we can talk it over on the phone. Let's see. We can also connect you to a legal advice hotline if something is beyond the complexity level that we're comfortable advising you about. There's also the court attorney in the help center, and also interpreters in the court are really important as well, because this can be very challenging for people who don't speak English at all, or where their English is a little bit tricky. Ideally, you want to tell the clerks that you need an interpreter from the very beginning of your case. But no matter what, if you have language needs, and if English is not your first language and you're just uncertain, you might as well ask the clerk for an interpreter. Whether that person can be made available that very day or at the return date. There's also a language line. So yeah, get help if help is needed, because often it is needed.
Yeah, on the interpreter, that's really important. It's your absolute right to have an interpreter in the language that you're most comfortable in. Sometimes legal issues come down to one word that sounds like another word, but it really means something different. So when there's language barrier, there's a real risk of it being lost in translation, what you're trying to say. So get that interpreter. It's really important.
Also, I think this is a good time to bring up your immigration status has no bearing on your defenses in court. You have the same rights as, a citizen, as a non-citizen for the defenses in court. What is different though, whether there are government benefits that you're eligible for, that your immigration status might matter then, but OSCs, your immigration status does not matter. And then, so this one, Kenny.
I don't know, since there's so little time, maybe we should throw it open to questions. Can you present new defenses that you didn't claim before? I'll say yes. Whatever it is that's on your side of the scales of justice, you want it to weigh on your side. Whether you've said it before or not, yeah, you could say anything that's important. I'll just leave it at that.
So we just have a few slides to go. What happens after you turn in your order show cause? So when you get to court, you get the form from the clerk, you then fill it out, bring a pen, they don't provide pens, and then you have to give it back to the clerk. And then you have to wait to see a judge the same day. So that's the thing. This is going to be a time-consuming process. You may not speak to the judge directly. Frequently, maybe like the judge's assistant, which is the court attorney, that speaks to you, but you will almost always get a decision the same day. if you have childcare, like your kid needs to be picked up from school at a certain time, and there's a high chance that you will be there all day. Make sure you have that child care, ready to go. Make sure you bring a charger with you, things like that. And if they're confused, whoever speaks to you, the judge looks over your order show cause, makes a decision, approve or, decline to sign. If you're confused, ask the person who's giving you the form back. What happened? Did you get approved? Do I have to serve? Ask the person right then and there. Don't leave if you still have questions remaining. You're allowed to ask questions. And get there early. A lot of the courts, you need to be there by a certain time. Like even though it says 9 to 5, you're not going to be able to get there at like 4:30. Some courts, they will not let people in, like Brooklyn Housing Court, they only allow emergencies after 4:30. So get there early. Possible decisions by a judge. So either the judge signs the order show cause and gives you a new court date. And if you have an eviction notice that stops the marshal from evicting you, just make sure you follow the service process. If you don't, potentially still an eviction can occur. If they declines the order show cause, they will have an X usually across the middle and the reason why it was declined. Again, if you can't read it, ask the person who's giving you the form back, what was the reason? Sometimes the judge will want to speak to you directly, so just be prepared for that. And sometimes it doesn't have a written reason why. Again, ask right then and there. Who's going to know better than the person making the decision? Sometimes in a situation, so the judge will suggest that you withdraw the OSC and do it at a different time. Ask the judge why, if anything is unclear. Sometimes it's because you did it too early. Certain courts, certain judges, they follow different policies. They may say, okay, this is too early. You don't have an eviction notice yet, or the deadline is not for another month. So you need to do it at a later time. So just ask if you're confused. You can always call us too. But if there's nothing written on it, it could be a little bit more difficult to determine why. So just ask. And then Angie.
So we're actually going to skip the service one just because we've addressed it mostly
Okay.
and we have very little time.
The one thing I want to say is that it has to be served exactly as directed, or no matter how strong your case is, there's a risk it'll be denied when you come back. So it has to be served exactly. If it says certificate of mailing, don't send it registered mail. Do exactly what they say.
Yeah.
Perfect.
Also, when you go to the post office, sometimes the post office worker, in trying to be helpful, will say, do you want the cheaper option? No, you want to follow the instructions exactly as it's written. If you're scheduled for the marshal the next day, you can ask the court, hey, can you call or fax the marshal the information? A lot of times courts will do that. So you can ask, if that doesn't work, serve the marshal the paper when they come to your door. And
So
then
this one I've got. Okay, so like we said, when you're doing an order to show cause, you're asking the court to set up a court date. So and it's a court date where both sides have an opportunity to be there. So it's going to be put on the calendar. It could be a few days, it could be a few months. There's no way to really know. But you definitely want to come to this court date prepared. You want to bring everything that you promised you were going to bring when you filled out the form. Bring it. Don't forget any of it. Anything that the judge told you to bring. If the judge said bring a money order for X amount, bring it. Right. Bring a pen. Get there early. Plan for this to potentially take a bunch of time. Any issue that you mentioned in your order to show cause for, be prepared to talk about it. And when you show up, you're initially going to be talking to the court attorney, who, the attorney that's like an assistant to the judge, and the landlord's lawyer. The landlord's lawyer might pressure you to sign an agreement or stipulation. The court attorney might also be pressuring you to sign a stipulation, but don't make an agreement that you can't keep, right? And if for example, you propose, I propose to move out by such and such a date, and the landlord's lawyer says, absolutely not, we can't agree with it. Eventually, it'll be the judge who makes a decision about what's going to happen, and for better or for worse.
Yeah. So, and the judge is going to want to see which side's being unreasonable. So, if the tenants has a good reason why they need till the end of June, the kids are in school and they blah blah blah, and the landlord's only offering the end of May, the judge is going to try to push one side or the other to fold. And so, if you have a good reason why you need the end of June, they're likely to pressure the landlord's attorney to do that. The one thing I wanted to add is to go to court knowing what you want the best outcome to be. Don't go there saying, oh, you know what's going to happen. Of course, you don't know what's going to happen, but at least having clear mind what you're asking for. That's very important, and it makes it more likely you'll get it.
Right. Next slide. Right. So the judge will either approve or deny your request. Right. And you might get the relief you asked for. If it's denied, the judge should tell you when the marshal can evict you, or when's the earliest the marshal could evict you. Sometimes it could be the next day if that's what the schedule said and the judge is refusing to change the timing of all this. But also it might be that the marshal has to serve you with another 14-day notice first. Again, there's a lot that we can't know about the timing right now.
Yeah. So if your order show clause is declined, what can you do? Again, it should be written. Maybe it's because you didn't provide proof and the judge wants that. Look at the reasoning why, so that you can file another one, and this time you can provide the documentation that the judge wants, or maybe the reason you filled it out incorrectly. Now, if your order show clause is declined, that means the judgment stays in effect, and if you have an eviction notice, the eviction can still take place. You can appeal the judge's or denial. So what you have to do is you have to appeal it to the appellate term, which is the higher court. And you have to go to the help center and the housing court to learn how to do this.
And again, this is reason why not to file these papers the day before the eviction, whether you need to refile it or go to the appellate term. Those each take a couple of days. So at least 3 days before the earliest eviction date should be the rule of thumb.
How many order to show cause can you file, Angie?
Hi, so we mentioned this earlier, technically as many, but the more you do, the least likely it is that the judge will approve it, especially if you don't have any proof. So yes, try to make every order to show cause count.
Here.
Oh, the tips. Okay. Yeah, don't wait until the last day before the earliest eviction date. Judge can always say no. Let's see, bring printed proof. The timing of order to show causes might be different from what you expect. Ask questions. Yeah, so I hope that has come across, right? Ask questions when you can't read what's written. Ask questions when you don't know if the marshal's notice has come or will come. Ask questions if you don't understand the stipulation. Ask questions. People who ask questions are more likely to get what they want. And in fact, also when it's time to negotiate a new stipulation, maybe, you get 0% of the things you don't ask for. So question askers get answers.
Yeah. And if you're confused about the earliest eviction date, when you get the marshal's notice, sometimes it's on the top right hand, but most of the time it's on the bottom left. It'll say earliest eviction date. That is the date you can be evicted. So 3 business days, not regular days, 3 business days before is the latest you should go into court to file an order show cause. And that is the end of our training. So
I just want to say, if I may, there were a couple of questions in the chat about succession rights and non-payment proceedings that are not the subject of this training. They are subjects of other trainings and handouts that Housing Court Answers have. And those questions can also be answered on the hotline.
All right. Do we have like maybe 5 to 10 minutes to answer any questions? Okay, just looking. What is the process for someone who missed their initial court date but is homebound and unable to make it to court to file an order to show cause?
Good one.
Oh, can I start? So someone who's homebound should be eligible for adult protective services, possibly. So either they or someone trying to help them should make the referral to adult protective services, I would say, and they may take it from there and get a guardian ad litem who could step in for them. I don't think the court is really equipped to deal with homebound filings at this time any other way.
And additionally, depending on the stage of the case, if somebody is homebound because they're 98 years old and they're also, in a wheelchair, and they haven't gotten a chance, they could potentially be high priority for the right to counsel program for a lawyer. So you can also call Housing Court Answers, and we can make a referral to ask the Office of Civil Justice if they could maybe assign a lawyer in this case. So homebound people, as long as you've got a phone that works, please call Housing Court Answers to brainstorm what can be done to address your situation. Definitely don't wait for a marshal to come.
Yeah, and to follow up with that scenario, if the court does not offer the RTC, so right to counsel at any given point, can a person use that as a reason for more time in an OSC? So I'm just going to speak to how it's working right now, regardless of whether you are getting a free lawyer or not. Right now, there's capacity issues. So even if you're eligible, you may not get a lawyer simply because there's not enough of them. Regardless of whether you're eligible or not, you can ask for an adjournment, which is a rescheduling, to get a lawyer. But if you don't get a lawyer, the court case is still going to move forward. The legal aspect, I can defer to Kenny.
Sorry, I was looking at the chat. Was there a specific question that you're referring?
If the court does not offer the right to counsel at any given point, can a person use that as a reason for more time in an OSC?
They can ask, and I think, the judges they know that there should be a right to counsel. They know it would be better, but they know there isn't one. It's not, so it carries a little bit of weight. The judge should be a little sympathetic if the person wants a lawyer and isn't getting one. The judge should be a little more sympathetic, a little more than they otherwise would be. But it doesn't guarantee anything.
I do know that I've definitely talked to tenants at the table who never were even told that it was possible to talk to a tenant lawyer before they got pressured into signing a stipulation at the first court date. And we've written it out on the order to show cause form, and it doesn't seem to be moving judges that much when they bring it up. I wish they cared more about it, but it's tricky.
Yeah. There's another question that says, are you guys seeing order to show causes that are approved, but they do not have a follow-up court date because of the backlog of cases? I don't think I've seen that, or I don't know if anyone's seen that. I don't know if you've seen that, Kenny.
Sorry, again, I was a little distracted. Go ahead. I'll stop doing that.
I'm sorry. Are you guys seeing order to show causes that are approved, but they do not have a follow-up court date because of backlog of cases?
No.
We've seen that for holdover, not order show causes.
Not for an order to show cause. No, that always it always has a court date. It's just when they except if you file an order to show cause, maybe for an HP proceeding. I'm not sure about that, but that's what we're talking about. And I think even that would always have a court date. So it's only new cases. I think like if file an answer. I'm not sure. Yeah, but for order to show cause, they always have.
Yeah, maybe the person who's asking that question, maybe you can send us like a copy of that. One you've seen, because I mean, we're seeing strange things happening because of backlogs, and maybe it'll become more frequent occurrence. But yeah, this is not really. Go ahead.
Oh, there was another question, a great question that we saw in the chat. So, is it always better to apply at HRA before filing an order to show cause? And Angie had said it's situational, which is very true. It so like if the marshal is coming tomorrow, um, don't wait. Like don't go to HRA go to court. But you also know, like if there's some time and you know that your order to show cause is going to be stronger if you're able to bring in printed proof that there is a pending one-shot deal application, then it does make sense to do the HRA application.
So you always want to file it as soon as possible. First of all, it takes a long, long time. You want it to be approved before you get a marshal's notice, not just to delay the marshal's notice. My daughter Hazel's one of her favorite expressions is the best time to plant a tree is 20 years ago. The second best time is right now. So if you haven't done it, by all means do it. But this, don't wait. As soon as you have a judgment, or even before you have a judgment, as soon as you have a rent demand, that's when people should be filing those one-shot deal or other applications.
Or yeah.
The judges don't like it
make
if
sure
you do
they'll
it
be
at the last
paid.
minute. They think you're just delaying and not serious. So for all
Also,
sorts of reasons.
and if anybody is unsure about what kinds of rent assistance they might be eligible for, they should call Housing Court Answers because we can talk you through it.
Yeah. Yeah, the court also has like HRA office, but I think it's only if if they're not busy, you may be able to apply there, but otherwise it's usually for people who have eviction notices and things like that. But yeah. You can also apply online at Access HRA. You don't have to physically go in person like the old days. You can start the application right then and there. Are there any guides available to help tenants prepare for an eviction? There's plenty of info on court proceedings, but not much on how to prepare at home for an eviction. So we have an info sheet about that on our tables, and you should be able to download a copy of that. We could post it, and just
short answer is that get your valuables, documents, valuables, medicine out of the apartment before the eviction. The landlord is legally required to maintain someone's property that's left in the apartment for 30 days. It could either be in the apartment, it could be taken away by movers on the day of the eviction, or the landlord could move it into storage. Things get lost, stolen, and broken, and it's very hard to get recourse. Once things are put in storage, the moving companies are very, very difficult to deal with. So the most important thing is, take photographs, I guess, of your property. If you do leave it behind, so you can prove if you have to sue for stolen or lost property, but get your valuables, your papers, and other stuff out of the apartment is a short answer.
yeah,
Pets can also, so just keep that in mind, that if you leave the day of an eviction to do an order to show cause, there's a chance that if you come back home and they've already evicted you, your pets are locked inside. So
there are rules about pets that the marshal is supposed to follow. It doesn't always get followed. Also, just to clarify, there's two types of evictions. One type of eviction is the marshal just locks the door. The other type is like a full eviction where they take your stuff out. The landlord will be present. They put it in a storage facility. So they're physically removing your stuff out of there and putting it in a storage. There's a lot of things that are supposed to happen, but does it always happen? It's like there's laws and there's what people actually do. So I just want to make that clear when you're facing eviction. I don't think we have any other questions. Things about succession rights, non-payment, this is not the focus of the case. And since we're past the time, if you guys have questions about that, please call our hotline. And I will share our hotline number on the chat, but I'll also repeat it, which is 212-962-4795. And yeah, and then our website on our YouTube, this training will be on our YouTube channel and it will be on our website. And we talked a lot about stipulations and things like that, and also NICEF. So those trainings are also on the YouTube channel. Like we have trainings about how to understand a stipulation. We have trainings about how to look up cases in NICEF. Feel free to check those trainings out. We are also having a training for anybody, some upcoming trainings for anybody who has Bengali speaking clients. We are actually having a training that will be translated into Bengali at the same time on overview of housing court. And that is next Tuesday. It'll be live stream. And the new good cause eviction law, everybody's super confused about that. So we are actually having a training about that on Friday. Feel free to register.
A meritorious defense and a holdover, right?
All right. Definitely. Maybe it'll make a difference in your case, but this is the end. And we just want to thank Kenny again very much for this assisting with our training, our pro bono lawyer for the day.
Thanks, everybody.
Thanks all for attending.
Thank you, everybody. Have a good afternoon and a great weekend.